All right. Hey guys, Tuesday was kind enough to send me the Zoom link. So I should be able to get this set up for us. Let me just, we're still early too. So just bear with me while I set up the Zoom. Oh, wow. It's been a long time since I signed in for Zoom, apparently. I have to remember which email account I used. I think it was. Verify my birth year. Jesus. So, hey guys, how are you doing? Good to see everybody. This is a day that the Tuesday after chemo, I'm always a little bit, it's the worst day of terms of reaction to it. So you feel kind of like you have a bad cold or something like that, but it's not really, it's not that bad. All right. One time passcode. This is, like I said, it's been a long time since I logged in. All right. So I'm into my Zoom. That's a good start. All right. Let me just put in the meeting number. Thanks for being patient. Okay, I should be logged in. Again, thank you very much, everybody. We can thank Tuesday Gazette for sending me this link so we can all watch this hearing. My wonderful moderator, Joe, has promised me that this will be an interesting hearing. Of course, no one can actually promise that, but she's a good source to understand what might be going on. She follows it very closely. Still going through the logins. Looks like okay. All right. So here, there is no live streaming of this hearing. Only SJC Rule 119 registered media may record. So I guess I probably can't. I'm not supposed to play this. And the thing is knowing somebody like Grant, who's very jealous and vindictive, if I played this, he would report it. That's just the nature of Grant, as everybody knows. So it looks like I'm not going to be able to play this hearing. We ran into this the last time too. I guess I will apply for the press pass for the courts, and so that in the future we'll have hearings. But it looks like I'm not going to be able to do this one here today. Yes, Elaine, thank you. I agree. I think it's probably too risky. Oh, that's Earl actually that said that. Earl, or Elaine too. Yeah. So I guess we'll just spend a few minutes discussing things here, but I have the Zoom number, Elaine, and I pulled it up. We can do it in our Discord, but it's still live streaming it though, right? So we don't have too many people in the Discord either. I don't know why they would do this. It seems like either you want this to be public or not. What's the big deal about making this streaming? But whatever the reason, this is what they've discussed. Oh, this is in Plymouth Superior Court, so that's where the civil case is taking place. It's not even in Norfolk, so they may just have different rules there than they did in Norfolk. Grant reported young jerks. He's such a little pussy. I swear to God, he really is. I had checked Law and Crime. They had nothing scheduled. Court TV had nothing scheduled. Fox 25 had nothing scheduled. So um, we'll give it another quick check right now, I guess, and see. But they usually schedule theirs ahead of time. I checked it about 2:15, so not that long ago. And wasn't there another channel like it's the Law and Crime Trials or something like that? It's maybe a spin-off channel, part of Law and Crime. I'm trying to look for that one too. Yeah, there's another channel, Law and Crime Trials. Let's look at this one. No, nothing scheduled here either. All right, I'm checking in chat now just to see if anybody has any other ideas. Allie says she used to think Grant was crazy, but now you can see he's nuts. Yep. But just not really a good, decent human being either. He's now just saying the wildest and wilder things, and these are just irresponsible things that hurt real human beings, and he doesn't care. So I mean, at this point, he's not really a real human being. He's just as irresponsible as any of the worst of the Karen Reed channels. We'll stay on for a few minutes and just have a little discussion. How are you guys doing? Yeah, now he's got John O'Keefe. I don't even want to repeat it, what he's saying. It's so absurd. This is what it is. This is the thing that this is what led to a lot of this problem here in this case and in other cases. Once you become addicted, once you set up your channel to create content, you have to there's now enormous pressure on you to create this entertainment material for other people in order to keep people coming to your channel. And I didn't succumb to that, but this is even what led to Turtle Boy in actuality doing what he did, that ultimately was witness intimidation. But what it was motivated by was the desire to create entertainment content for his channel. And there's just enormous pressure. So he starts doing calls where he's calling up the witnesses and doing hang up calls and trying to, make them seem entertaining and funny. And his audience was eating it up. Or then he's going to Canton to perform stunts. But all of that was driven by the need to come up with entertainment content for his channel. Same with harassing Jen McCabe at the lacrosse game. That wasn't out of any journalistic desire. That was simply it really wasn't even motivated by any desire to change the witness testimonies. He knew it wouldn't do that. It was about generating entertainment. And this is what happens in this world here of content creation. Just that enormous pressure. And some of these channels are covering the Nancy Guthrie thing like 18 hours a day. And there's just enormous, and they cover, they're following around every little thing that goes on in that town. So just to let people know, I'm still talking right now, but we're probably not going to be able to stream this. Tuesday Gazette was kind enough to give me the Zoom feed, the Zoom number, but when I got in there, there was a message that we're not allowed to live stream this unless you have permission from the SJC or the court. There is to be no live streaming of this hearing. This is per SJC Rule 119. So unless you're only registered media may record. So I am not registered media, so I will not be able to show this. So I don't want to. I don't believe it's on Law and Crime. I've looked there as recently as a few minutes ago, and there's nothing set up on it. There's no show set up. So unless they set it up at the very last minute, maybe they'll set it up at 5 or 3. I don't know. Watch it and give you the bullet points. Well, I mean, I think most people are probably going to want to go watch it, on their own, wherever I'm not going to promote anybody else's, but, they'll go where they want to go, whether it's, like I said, you know where to find it. I suppose we could watch it on Grant's channel, but turn down the volume on his channel to 0. And so we'll be giving him the view, but then we can just talk about it on our own. Not that I don't talk during the hearings, but we could comment on it on our own here and chat and then talk about it after the hearing. So have you guys been following the Nancy Guthrie case? Do you guys have any theories? It's kind of a tough one to get. We have such limited information. For me, the thing that I focus on is I just don't understand why the guy on the camera there, so the presumed abductor or killer or whatever it turns out to be, I don't understand why he would. Lavender, you're so. Oh, I forgot. You guys can't see her. There's someone named Lavender who's an FKR, and one of the this is saying a lot too. One of the less bright ones too, but for some reason she always follows anything that I do on Twitter. But you guys can't see her comments, so because she's comment just from Twitter. So which really very few people do comment from Twitter, so nobody is really seeing it but me. But anyways, in the Guthrie case. Why was that guy displaying his gun so out front like that? I mean, you go to someone's door like that, if they look at their Ring video, if they get a notification, or if they look out their window, they see a guy in a ski mask with a gun out front, they're going to call the police. So it seems like that guy, there might be something wrong with him. Like he might not be the sharpest tool in the shed, that he's doing something like that. And if he's not the sharper, if he is a little bit off, then he's probably working by himself, you know? And so I don't know. So for me, I would just my guess, but it's such a based on so little information. I'm guessing that this involves kind of a nutty character that is doing this on his own. I don't know how he get into the house. Obviously, the police probably know at this point. Did he break in? Was the door open? Did she let him in? Did he find a key outside? Did he have some kind of information that told him where there would be a key? You know, just don't know. Also, trying to cover up the camera with a plant that he pulled from the ground. I don't understand that. That doesn't make any sense. Um, obviously, if you really knew what you were doing, you'd bring some tape with you. Like some electric tape. But how is that ever going to cover the camera just by holding a plant over it? Unless it was some kind of a camera that has, unless it was some kind of camera that has, I'm sorry, some kind of plant that wasn't a real plant, but a decorative plant that had a piece of something where you could use it to hang on the camera. I don't know. And then he's in the house for 45 minutes, supposedly. I don't even want to speculate on what could have happened during that time. So Deborah thinks that he had an accomplice. Thank you, Dog. I appreciate it. I wish I could carry this hearing for you. I want to repeat again for everybody that's come here. I probably will not be able to get this hearing so that you'll be able to see it. So what we could do is go to Grant's channel and just kind of watch it with the volume down and watch it. When I see, the thing is, you want to watch it somewhere where nobody talks over it. And so many of these other weird channels, they talk over it. So Grant isn't going to sit there and just be quiet while the hearing's on. He's going to be saying Grant-like things, and nobody wants to hear that. And he's Melody Little does that. I don't know if Roberta does that, but to talk over the hearing, I don't know why people would do that, but they do it. Grant doesn't have the channel either, so I don't even know where we'd go then. Grant doesn't have HWV38T. I don't know what that means. And Mike says Roberta can't get it. So yeah, it's not 3 yet, so nothing's happening yet. We still have about 5 minutes. If it starts on time, it'll start at 3. Roberta is quiet during the hearing. Okay, good to know. I just don't understand those channels where people talk over it. I'm not going to, there's some other ones that are even friendly to our side that do that, and I don't understand it. Why? Just be quiet, damn it. I don't think it's big enough. It's just a civil hearing, pretrial hearing. I don't think it's big enough to be covered by court TV or law and crime. I think that's the issue. It's just not big enough. Hi, Cindy. Thank you. No, I'm fine. I just haven't really had anything in particular to talk about. I'm thinking about I asked the AI to give me some ideas about what to do for a channel, and Grant is crying right now again. They're not real tears though; they're Grant tears. But anyways, the AI suggested I do a series on disappearance cases, like Guthrie, but not Guthrie, and where there's been some recent developments, relatively recent. I like meaning in the last couple of years. For instance, it suggested Maura Murray, which I did a series on her like 4 years ago. So maybe I could do something on that. Brianna Maitland, and there was a few other cases that are brought up that seemed interesting that I had never heard of. So maybe I could do a series on those. That's really just why I haven't been doing shows. I haven't had any particular things to do. I've tried to do spaces too, but it only works for me if I go on as somebody's co-host, because when I set up my spaces myself, I get automatic disconnects. This is some problem that the spaces has connecting to my Wi-Fi. Judy Smith case. Okay. We'll look into it. And even though it disconnects only for a half a second on my Wi-Fi, because the Spaces does not do buffering, that's enough that it bumps me out. And then for some reason, when it lets me back in, it doesn't activate my mic. Even though it shows the mic is active, nobody can hear me. So it's even more frustrating because the mic shows as active. So I'm speaking, but then eventually I realize nobody can hear me because someone's saying, "What happened to Kevin? How come we can't hear him?" And so it's really the technology issue is with space, it's with X and Spaces itself. Elon Musk has to straighten that system out. It's not working well. But some people I have a worse problem with it than most people might. And I bought an extender, a Wi-Fi booster, but that doesn't work. And before I even tried that, the AI told me that extenders don't work for that at all. They actually are bigger problems. So we're maybe going to do one of our friends here, Truth Over Bias, is going to do a Spaces show after this hearing, maybe. And if we stay live, I can hold the mic down so people can come on and talk. I don't know. We're just toying with the idea. We'll see. But it's hard to do if we don't get the actual hearing. So, no, I think the issue, Hard Star, is just that this is not in the same court. This is in Plymouth, and they have different rules. Jesus Del Cruz case. I don't know that one. But feel free to email me, anybody, anytime, if you have a case that you think that we'd be all interested in. So Leitzkev, Leitskev, at gmail.com. And one of the things that I'm not sure, we're almost at 3. I'm not sure if I should be quiet. Let's take a look again and see if any channels brought this up that we can jump on. Last ditch effort. Doesn't seem to be on Fox 25. Try WCVB. Looks like we got some snow on the way. Nope, I don't see anything on this. Just jump back to chat. Did you guys find it anywhere? I have the Zoom open. It has not started yet. So it has not started yet anyway. So nobody's missing anything yet. I have the Zoom open, and when it does start, I'll tell you guys so you can go find it wherever it is, whoever's covering it. Anyways, I was telling people on Spaces the other day. So, the big issue with we want the mainstream media to cover the very unusual connection between Karen Reed and the feds, and in particular, that we recently learned, as we've talked about, that Karen graduated high school with a very high up prosecutor for the feds. Her name is Ann Peruti. She is actually chief of the Major Crimes Department. So she's very high up within the U.S. Attorney's Office. And she happens to be the one who also prosecuted the leaking grand juror case. And that grand juror was leaking to who? Was leaking to Turtle Boy. And from what grand jury? But the one that was about the CDL cases, but also primarily about the Karen Reed investigation. Extremely inappropriate that Ann Peruti, we don't know how close she was to Karen, but they followed each other on Pinterest. That's the best we could do. And we found messaging between Ann's twin sister, Trisha, and Karen. But other than that, we don't know how close Ann was to Karen, if at all. after high school. Thank you, Carrie. I appreciate it. I don't really deserve it here because I'm not able to find any way to broadcast this legally. So, maybe I should. I don't know. I don't know if there's a way to turn off super chats because I don't want to take money when I'm not able to actually do what you guys think I'm doing. I thought we'd be able to find it, but I don't think I'm going to be allowed to find it or allowed to broadcast it. Oh, it is on now. I'm having trouble getting any audio though. I have to pull these off and try it another way. Okay, I think I have the audio now, but nobody's speaking, it looks like. Alan Jackson is there. As well as 1, 2, 3, 4, 5 lawyers and the judge. Just nobody's speaking at the moment. Nobody's speaking on my end. Maybe it's a few seconds behind or something. I don't know. Hold on a second. Let me change one more volume thing.
Arguments accordingly.
Okay, I got the judge talking now. I got it.
Thank you, Ron. I appreciate the opportunity, and I think you synthesizing the issues really will cut to the chase here. You referenced the charm case, Judge, and of all the cases that there are on inadvertent disclosure, and there are many in Massachusetts, and there are many around the country, the charm case could not be more on point. Judge Fabricant faced the exact same issue.
It's probably the only case about a client inadvertent disclosure in Massachusetts, right?
That is correct, John. I was not able to find anything else where, as you said, it's normally the lawyer who includes something in a batch of documents, or an outside service has included something in a batch of documents, and the lawyer on the other side of the case gets that inadvertent disclosure. Here you have, in the advent of digital communications, you have an attorney in charm emailing opposing counsel, copying his co-counsel, blind copying his client. The client gets the communication, intending only to respond to his lawyer, writes back to everybody through a reply all. Judge Fabricant explains how that can happen to anybody. And what she does is she analyzes whether or not the lawyer and the client acted expeditiously, and she uses the word used maximum effort to recognize the error, address the error, try and reclaim the communication because it was not a voluntary disclosure. In that case, Judge Fabricant granted the motion to strike that email, agreed that there was no waiver, because the lawyer, even though he had done that once before, he had blind copied his client, and the client had replied all. And even though the lawyer in that case simply asked the receiving lawyer to delete, destroy, and not use the email, did nothing more. Months later, that email is attached to an exhibit to a motion for summary judgment opposition, and suddenly the lawyer thinks he needs to move to strike. So the email really wasn't reclaimed in the same way we have done, in stark contrast to that case and those facts. I've sworn in an affidavit which you credit, Your Honor, and I appreciate that because it's sworn in. I stand by it. This is a one-time event, one-time incident where Ms. Reed was blind copied. Inadvertently, she replied to all, not intending for anyone but her counsel to get that reply. That squares with charm. Immediately, my colleague Aaron Rosenberg reached out to Mr. Diller. That was 39 minutes later. Recognized there was a reply to all, recognized there was an inadvertent disclosure, demanded that it be deleted, destroyed, and not used. Mr. Diller said no, or didn't respond. I then reached out 44 minutes later, confirming, delete it, confirm you've deleted, don't use it, confirm you're not going to use it. Same thing, trying maximum effort to reclaim the privilege, to reclaim the inadvertent disclosure. We then had back and forth with Mr. Diller for a number of days. He refused to comply with us. We then served a motion. So we used the maximum effort. There was no pattern of behavior like this that you saw in Charm. There was maximum effort to reclaim it. So when you look at Judge Fabricant's analysis of the efforts by the client and her counsel, that we've done even more than Judge Fabricant allowed in granting the motion to strike. This is, by Attorney Diller, an opportunity which is evidenced in his opposition motion, Your Honor. Actually goes so far as to make a motion that he says Reed and her team, in all likelihood, by her direction and or recommendation of counsel, has been blind copied on all email communications with opposing counsel since the outset of the lawsuit. That is an outrageously inaccurate statement. It doesn't even comply with Rule 11, where a lawyer signs his name to pleadings and certifies that he has a good faith basis to make such a claim. What that means is Mr. Diller is trying to take facts that don't exist, create this narrative of recklessness, which does not exist. Ms. Reed was blind copied once, replied all once, and trying to fit that squarely in to get around what Judge Fabricant says in her opinion, which is lawyers should not take the opportunity to use something like this as an inadvertent disclosure and take advantage of that. Your Honor, for the same reasons in Charm, you should rule that there was no waiver of the attorney-client privilege here. This was not a voluntary waiver. This was an inadvertent disclosure. This fits squarely with Charm. We've done more than the lawyer in Charm did. We've acted faster than the lawyer in Charm did. We've proven there was no pattern like there was in Charm. And Judge Fabricant still understood the importance of the most sacred of privileges, the attorney-client privilege, and did not allow those facts to erode it. And we asked you to reach the same conclusion, Your Honor. Regarding the impeachment value of this email, we'll provide you the email in camera as you have ordered, and you will see that it squarely fits with everything Ms. Reed has answered in the second interrogatory that was posed to her. So it has no impeachment value. The plaintiff's attorney was asked to return it. There's plenty of discussion in the rules of professional responsibility in the case law about returning an email that's been inadvertently disclosed. Judge Fabricant speaks about, to quote her, she says, as a matter of courtesy and in recognition of their own vulnerability, lawyers should avoid the temptation to seize opportunities arising from inadvertent disclosure. It's just, this should just end today. Mr. Diller should not be permitted to use it. He should not be permitted to disseminate it, and it should be destroyed. We've done everything we can to reclaim it, and I rest on those cases, Your Honor.
So you argued in your papers, and you just argued now about impeachment relative to the answer to interrogatory and the email. But what about in the future, if there were some statement under oath by your client?
Your Honor, there will not be a statement under oath that the email can be used for impeachment purposes. Mr. Diller
we hope not, because we're all, as lawyers, tell our clients that they can't commit perjury, but not all our clients listen to us all the time. At least my clients didn't always listen to me. So just the possibility of that in the future.
I understand, but I think the answer will be very clear for Your Honor once you see what is in the email and you compare it with what is in the interrogatory answers. I have to tread lightly because I don't want to say anything about the email, but you will see that once you read the email and you compare it with the interrogatory answers, if there was something inconsistent with the interrogatory answers, then sure, then Mr. Diller can use that for impeachment purposes. But the email itself has no impeachment value once you look at it with the interrogatory answer. There have been 2 interrogatories served on Ms. Reed. The second one asks her, and we suggested that to Mr. Diller because we were going back and forth about whether or not the first interrogatory answer he thought was needed clarification or expansion. So we suggested to him, ask another interrogatory about stating the basis for the affirmative defense in the answer to the complaint, which states somebody else was responsible for the death of John O'Keefe. In response to that interrogatory answer, we have, with Ms. Reed, assisted her, and she has signed her interrogatory answer that is consistent with what's in that email. So there's no impeachment value. You can use the interrogatory answers. What we're trying to avoid is him making the argument that somehow she has waived the privilege and he can use the email. There's no basis for it, and I think that in-camera review will answer that question squarely for you, Judge.
Okay, thank you. Attorney Diller?
Your Honor, thank you. I want to address first and foremost what was just raised, which is the reply brief. I think it's noteworthy that counsel for the defense did not file this motion under seal. In fact, they attached a reply brief that says verbatim, comparing this answer to the privileged communication demonstrates that there are no areas for impeachment unique to the privileged communication. And then they add as an attachment to that email the answer to interrogatory under oath statement signed by Ken Reed, all of which, given what's happened in this case, has been picked up in the news and become part of the public domain. The law's privilege is waived when its contents become public. Counsel, to the extent that there may have been a privileged communication in the email to which I did not disseminate, chose to put its contents directly into a public filing and attach the answer to interrogatory to which Attorney Seligson just communicated to you, stands for the same issues and the same facts are lying. Now, I appreciate that your honor wants to look at this in camera. I would say to you that I'm not really sure why we are here at this point, given that I understand why it was served. I did not disseminate it based on an agreement that I had with them, but I did point out case law why I believed that I could use it to impeach credibility, given that there were other statements that I believe to be inconsistent with that. And then I understand after I served my opposition, why then it would be filed. But I didn't understand why there was no attempt by counsel to seek an in-seal filing of this together with the answer to interrogatory and/or an in-camera on all of it. I feel as if in Judge Fabricant's 2010 order, she's very clear that she says a client who seeks to preserve the privilege has the responsibility to be careful, particularly when using a means of communication that poses known and obvious risks. Lawyers should advise clients to be careful and avoid practices that exact those risks. And then Fabricant gives a public warning to the bar in general. It says others should take note. Reply all is risky, so is BCC. Further carelessness may compel a finding of waiver of privilege. That was 16 years ago. The world and technology has advanced. We have all become more sophisticated with way to deal with it. We were also relying on an MCLE, which was written by a gentleman who was with the BBO, that says an argument could be made that privilege is now waived when a client replies all to something that they were copied on. That just deals with the first issue, which I think the whole thing has been waived regardless of how you interpret Fabricant's decision. But the second issue, as it relates to impeachment, we have the late, great Judge Gantz, who wrote an opinion. We have Justice Kaplan, who both issued opinions. Both suggest you can't unring the bell. I identified that there were inconsistent statements in the email that was provided to me before anybody tried to recall it or advise me that that was intended as a client confidential communication. I then said, I'm not intending to disseminate it, but I do believe in arguments made that she's waived it, and I more so think it's significant that should she give inconsistent testimony moving forward, it certainly has impeachment value, which has been borne out by Justice Gantz, Justice Kaplan's Superior Court decisions that talk about the impeachment value of it. So ultimately, I stand by the position that, for starters, I believe that they have waived the any privilege that may have existed in the communication by publicly disseminating the contents of it. And then secondarily, I have every right to use it for impeachment purposes as we move forward in this litigation. Your Honor, I rest on the papers as it relates, or will answer any questions that Your Honor has.
Your Honor, may I respond?
Sure, go right ahead.
Your Honor, the notion that a litigant would be served with an interrogatory, answer the interrogatory under oath, and then somehow be deemed to have waived the privilege is preposterous. What I am arguing is, for impeachment value, there is none. And once you are able to see the email and compare it with the interrogatory answer, you will make that decision for yourself, I am confident. But if Mr. Diller served us with a motion and we served him with a motion, and he attached signed interrogatory answers, or we attached signed interrogatory answers that had been served in the normal course, there's no waiver of the privilege. That's just not a valid argument. Secondly, Mr. Diller cites two cases in his brief, which is referenced today. Those cases actually stand for the proposition that there has been no waiver. The cases that he cites to, the Mirror Inc. versus O'Brien, the court found that Judge Gans found that there was no waiver of the attorney-client privilege with an inadvertent disclosure. The case that he cites to in his brief, and he mentions as well, this is Judge Kaplan, Vigor Works versus Scansa. Judge Kaplan finds there was no waiver. Your Honor, again, this is desperation. It's an inadvertent disclosure. We've done everything we can to prove to the court under the reasonableness standard that Judge Fabricant lays out in Charm. It's the same fact pattern. Same conclusion should be reached. Ask your court to allow the motion that the privilege has not been waived in part or in whole whatsoever, and that Mr. Diller, his clients, and anyone else who has had a look at that email be ordered not to be able to use it. Thank you, Judge.
Okay, thank you. I'll take the matter under advisement.
Thank you, Your Honor.
Thank you, Judge.
Thank you. All this matter is under advisement. This matter has a next date of March 5th, 2026 at 3 p.m. for the Rule 16 conference. Thank you all.
Okay, that's all, folks. So we don't know what's in the email still. And it would appear that Karen has said something in the email that either may be inconsistent with something else she has said in the past or something she may say in the future. And they want the right to use this to impeach her credibility. We can't really know what that is at this point. So part of the Karen side wants to just exclude it outright. But if there's any question, they want the judge to view it in camera. So the judge would look at it himself and decide if there was anything that could be relevant. Because they claim that in addition to this not in any way impinging on her attorney-client privilege, that it also is irrelevant. Now, see, if you have attorney-client privilege, meaning the one side cannot use information against the client if it was something that was attorney-client privilege. But if it was something that was made public, then they're using it from a public source. So, for instance, let's say it went to the media or something like that, it went to the media because of a choice made by the plaintiff or the defendant. Remember, this is a civil trial. So let me see if they're ready to start. Truth, are you here? Are you guys ready to start the Spaces show yet? And then we'd be able to. Actually, maybe they already started it. Let me check. So what we're going to do is set it up on Spaces at the same time that we stay live here. So if anybody wants to come on and share their audio opinion with the audience, they can. Trying to see if anybody is doing a Spaces. But I know Truth is going to start one for us. Truth is setting it up right now. Okay, so hang tight. So if you guys want to communicate with us, what I'll do is when you speak, I will hold the mic down to my phone. And this phone has a pretty good speaker too, so we should be able to hear it very clearly. Shemina, that was not an odd. See, the problem with that is that that's the civil hearing, and the Plymouth court does not allow us to restream it. So I had no choice. I probably, as it was, broke the rules maybe a little bit just by keeping my mic within range, but I don't think that's probably a big enough deal that anybody would have a problem with it. So I don't know. Hopefully not. I'm not even sure anybody could hear it. Most people probably just went to one of the other channels. Okay, I'm joining the hearing. If it's possible, Truth, you could make me a co-host.
I'm trying to share. So once Kevin joins,
I am here.
then I can put him on and people can talk to him.
I am here.
That was very stressful. That's my first time ever going into Zoom for something like that. So scared.
All right.
Share it, girl.
Hey, guys.
Hi.
Hey.
Kevin.
Hey, how you doing? How's it going? Always
I'm good.
tricky technology, huh?
Yeah. So we'll read any questions that are in the chat to you.
Yeah, and anybody that wants to speak, I can hold the mic up too. And so we're still live on YouTube.
So we can hear you really good. So wherever you put the microphone, I'll tell you, like if it's close to the speaker, I'll tell you if we can hear it good. And then you don't have to move it because you're connected.
Okay. Yeah, this phone has a very good speaker. So
yeah.
now I've already lost my first connection but it usually reconnects fast. That's why. Yeah. It's so bizarre. I don't know why.
He should be able to come back right back, girl. Okay.
Am I back? Can you hear me?
Yeah, there's Maui.
Can you hear me?
Maui.
Can you guys hear me at all? Or
I see Anita. Yeah, I'm so glad Anita's here. Elevate the process.
are you guys able to hear me? It's so funny. It doesn't. I guess not.
So I learned a new trick, Earl, that I'd be able to remove Kevin if he ever loses his microphone, and then I'd be able to add him back. I learned that trick.
Can you guys can't hear me now, right?
Kevin, if he ever loses his microphone, and then I'd be able to add him back. I learned that trick.
I'm guessing that no one's replying, so I'm guessing.
Just listen to what he's saying, so I'm gonna mute for a sec. Okay. Oh, there he is. He's back.
There you are.
Can I invite him again, or do you think he should just pop back up? I'm not sure. Okay, I'm still trying to send invites. I'm sorry, I'm distracted. That's okay.
So as we're still live on YouTube too, so just saying.
I'm gonna mute because I just have to.
All right. Unfortunately, I get these disconnects all the time. It's nothing that I can do anything about. So now I'm back as co-host. It didn't take long for that first disconnect to hit.
Yeah, it didn't let you reconnect back in as a co-host, hey?
I guess not. And not only that, it was showing my mic is active, but I could tell you guys couldn't hear me.
Okay, so if that happens, somebody just say something in the comments because I am able to remove him and add him again.
Yeah.
Oh, Kate's here. I invited her. Okay.
Hey, Kate. Oh, she's just as a listener at the moment. Yeah.
Kate did a space this morning, so she might be
spaced out.
Yeah, spaced out. Oh, that's a good one.
We'll have to use that again.
Yeah. It was funny because Drew was speaking and just all of a sudden the Spaces music started playing and Kate disappeared and Drew was like, did I just have a stroke? And Drew said, Kate, blink twice with your profile picture if you're okay. And I was laughing so hard. Yeah, that was funny. It was hilarious. Okay.
How is the quality of this?
At the comments to see if anybody wants to speak. Oh, Kate, just give me a few minutes. I've got a vacuum.
How's the quality of the sound coming over this? Can you hear me? Can you guys hear me?
I'm hoping some more people will join.
Can you guys hear me? I guess not.
I'm hoping some more people will join before we start discussing. I sent some invites. If you guys could, everybody, share the space on your timeline. Okay. You're back, Kevin.
So don't make me co-host. Maybe it's I just
I just added you as a speaker this
Yeah.
time to see if that works.
Right. That seemed to work better the other day when I would get disconnects. It would bring me right back in after a second. So yeah, let's just try it that way.
Okay. Hey, Kevin, sometimes if I move to a different room in my house, it fixes it. I don't know. He can't do that because he's on YouTube too.
Yeah,
Oh, sorry. Yeah.
that's okay.
If anyone else has any questions, comments, or anything, just request to speak.
Have you been able to hear over the phone other people that are talking? Can you hear that on my YouTube channel well enough?
I have you muted on YouTube.
Okay. I'll check on the YouTube for comments to see if people can hear. Real Housewives says, what is going on here on YouTube? So Housewives, we're just trying to test this way of using this, combining YouTube with Twitter Spaces or X Spaces, so that people that want to come in and join us and talk, they can still be able, we can hear them on the YouTube. So we're trying to make this work together, if that makes any kind of sense. But sometimes we have a problem where for some reason I get booted a lot because of the Wi-Fi connection or something. See if anybody else wants to speak. Is Maui still here? Did she want to speak? Or
Boomer's here.
Boomer's here? Haven't seen Boomer in a while.
Boomer, come up. I'll invite him.
Good to see you, Boomer.
Jams is here.
Hey, Jams. I don't know if my moderator, Joe, is here. She's also moderator for Forensic Room. Ooh, I almost blew it again.
There's Elaine and Chick from the Bricks, Mike, Lisa, Heather, Renata, Chastity, Naughty Kitty. Everyone's joining. There's Richard.
I had an idea for a project that I put on.
There's Martin.
Hey,
Boomer. Okay, I'll mute and y'all chat.
Okay.
Hold on, I'll be right back.
His volume might be a little low, but I had an idea for a project.
Like ready to not chat, and Boomer's like, never mind.
I had an idea for a little project. Can you guys hear?
There's Thomas. I don't think I follow Thomas on here.
Can you guys hear me? Guess not.
Elaine and Liz, Rose. Rose changed her profile picture. It's cute.
Can you guys hear me?
I feel like Kate this morning, just talking to myself.
I'm talking, but I guess no one can hear me.
Changed her profile picture. It's cute. I feel like Kate this morning, just talking to myself.
I put in another request to speak. I'm not even seeing disconnect messages anymore. It just, oh, no, it disconnected again. It's just so bad. It's just, I guess it's just not going to.
Happening?
I don't know. Can you guys hear me?
Oh, okay.
Yeah.
Are you there, Kevin?
I am, but the disconnects are just coming so fast and frequent, and they don't reconnect properly. And I can't tell when people can hear me or not. Can you hear me?
Can y'all hear me? I feel like I'm all alone here.
I'm speaking, but
Okay.
I don't think anybody can hear me. I can hear you though, Truth.
Okay.
I can.
Thanks, Truth. Nosy requested, and then
Or I
she
can.
went away, and now Kevin is not a speaker. This is madness. There's Nosy.
I don't know. Can you hear me?
Hey, Nosy. What are you?
I just thought I'd tell you we can't hear you.
Oh, thank you. I don't know what happened to Kevin. Kevin? Oh, this has got to be so frustrating for him. I don't understand.
He's showing as a speaker again.
It's showing as a speaker. No one can hear me.
Oh, this has got to be so frustrating for him.
All right.
I
So
understand.
He's showing as a speaker again, but it's just not looking like he's actually kind of talking, or the mic's not picking him up. One of the two.
Oh, there's Kevin. Okay.
yeah, it's just not working. The disconnect. I'm not even touching my phone, but the disconnects come so fast, and sometimes they don't even hook up. But I can't tell because my mic will show as active, but I can tell you guys. I don't even know if you can hear me now.
I can hear you now, but that is so frustrating. I don't understand.
Yeah. I'm not that far from the Wi-Fi, but I also cannot go into the room where the Wi-Fi is because there's somebody in there right now using it.
Yeah.
So that's why I got the extender. But apparently, according to the AI, the extender will just make things worse in terms of disconnects. So I don't really understand it. It's really bad technology that where it actually disconnects and doesn't tell you and leaves your mic looking like it's working. And so you can't tell that no one can hear you. It's really frustrating.
Yeah, that's so frustrating. Well, while you're there, can you go ahead and just tell us your thoughts real quick, maybe before you get kicked off again, or do you want to just say no?
Yeah, I'll just repeat what I said before, and I'm no expert on this, but it's obviously Karen had hit reply all, and the other side is saying that there was something in that email which may be able to be used by them at some point to impeach her, some inconsistency, either with something that she has said before or someone that she may say in the future, and they want the right to be able to use that to impeach her credibility, and and her side obviously doesn't want to have that kind of exposure. So I don't know how big of a deal it is because we haven't, and they also willing. Her side is also willing to have the judge review it in camera and decide if there was anything that potentially could result in impeaching her credibility.
So, will the judge be able to see what she said?
If the judge decides to review that in camera, then yes. But first, the judge, the judge has to decide, based on the case law, whether she actually has, even in any partial way, lost attorney-client's privilege, because this reply all apparently went to a public place. So it's kind of like if you, and I'm not a lawyer, obviously, so I'm just making sense of this. Let's say you deliberately gave something to the media, and then it became public. And then later on, you wanted to claim attorney-client privilege, but the other side says, we're just taking this from the public source. We're taking this from the Boston Herald article that you did. So it's maybe she, like, for instance, in an interview or something like that. I mean, once it was made public, the argument is that she lost attorney-client privilege. I'm giving my amateur interpretation of that. I'm sure people can give a much better. Certainly, if we can get a lawyer on, maybe Maui can give us a better explanation of that. Not that Maui's a lawyer, but Maui usually has pretty on point understanding of this stuff.
Oh yeah, Maui's amazing. Yeah, Maui's amazing.
Looks like I may be lost or not. I did get a.
No, you're there.
Oh, okay. You can never tell with this thing.
Oh,
so
spoke too soon.
Am I gone?
So frustrating.
There's a pattern with this I've noticed with Kevin, is that he will say, I've lost everybody, we'll still hear him for 2 seconds, and then he'll disappear.
Yeah. Yep. Yeah.
So, and now he's connected again.
Can you hear me now?
But yeah.
So I'm not.
What are your thoughts, Nosy, on today?
Well, I only managed to get a little bit of it because I actually managed to log in, and then I was worried that they'd see me, so I'm putting cloths over my webcam and everything to make sure they couldn't see me. And logged in under a different name. So I'm going incognito. I don't know, because I want to go and see it from the start, from when I only saw it halfway through. But they're fighting really hard for an email that's unimportant.
That's right. Yep.
Because I only saw it halfway through, but I'm fighting really hard for an email that's unimportant.
That's right.
Stuff is just making me laugh so much.
Yeah, and Diller is always just so calm and gentlemanly, and Karen's lawyers are always just so petulant and salty. It's a very interesting contrast.
Did you feel like when you were,
like lawyers like clients?
did you feel when you were watching it too? It's like Seligson wanted to respond, and then Diller didn't even respond to what his second response was. I found that interesting. Like he seems pretty confident in it.
Yes, I'm gonna have another look through. I'm gonna rewatch it again from the beginning because
That's a good point, Truth. Yeah, he was just like, Diller was just like, okay, keep arguing. Go ahead. I know I'm right.
Yeah, I wouldn't want to get on the wrong side of Diller.
No, I mean, I am so impressed with him. I'm so glad that he is an advocate for the O'Keefes.
Now, is Kevin back?
Can you guys hear me?
Yeah, hi, Kevin. Go ahead.
So what I've been doing, just to want to let you know, I've been holding the mic so the people on the YouTube can still hear your conversation. So they've been able to hear it all.
I would love to hear Tuesday's interpretation of it, or Jan's.
Yeah, or Maui.
Maui. I think Maui might be at work. I'm not sure. Kate, when she's done vacuuming.
Yeah. I wish Critical Mass was here because that person is an attorney. I know that.
Yeah.
We've asked that person to speak before and they haven't been able to. So, I mean, I understand. It's stressful. Whatever you put on a space, I've learned it's stressful. Like,
I'm going to read some comments. So Jules would like to know, so what's the word? What happened in the hearing? And Cowboy Fan, I'm sure Karen threatened AJ to fix her mistake.
So I guess Grant is now, someone's saying, Heartstar is saying in my chat that Grant is now saying that Karen was framed, which I predicted months ago.
Oh.
Yeah, he was crying or pretending to cry, saying, "Oh, Proctor murdered John O'Keefe." It was just
Now Proctor murdered him?
Yeah, or he was an accessory to murder, and he was showing video of the Sally Port and saying, or like the car in the Sally Port, and saying that proved that Karen was framed and that Proctor did this and that, and he was pretending to cry.
He must be getting some donations.
Amanda Kirby in the chat said that Grant said the judge was admonishing the O'Keefe's lawyer, but they heard nothing, or she heard nothing like that.
Yeah, I didn't hear that at all.
Before Reed's lawyer spoke.
That's why I'm going to go back and have a look from the start, because I want to kind of go against what Grant has said, because I've got this thing with Grant at the moment where I just need to annoy him at every level.
You go, Nosy, you go.
Are you not blocked yet, Nosy?
No, I'm surprised actually, considering how many times I've kind of tweeted at him in the last couple of days, kind of telling him he was an absolute lunatic, and proving him wrong on every single thing to do with what he's claiming about John O'Keefe. But no, he hasn't blocked me yet, which I'm quite shocked about.
He never blocked me either, and I was correcting him all the time, and he never blocked me.
I'm trying my utmost to get him to block me, but he's just not doing it. So I'm going to go and have a listen to this, and if I hear anything of what he's saying, I'll come back and let you guys know. I'll let you guys know either way.
Yeah, just mute and stay up as a speaker, and then go listen and let us know.
Okay. All right. See you in a bit.
The reason he probably doesn't block is because he's only getting usually 4 or 5 comments under his posts. So even if it's a negative comment or someone correcting him, that's still good for the algorithm. At least it looks like he gets some comments. That's probably why he leaves it up.
Yeah, Elaine said the email must be bad if AJ was there. What do you think, Kevin?
Yeah, it was interesting to see him there, but I don't know if we can necessarily conclude that. I don't know. It's hard to tell without it's hard. You don't want to speculate if we haven't seen it. You know, I don't think it's generally in life, or especially in trials, if you're expecting a bombshell, you're going to be disappointed, right?
Yeah.
There are very few bombshells, And so he probably, I did email anonymous masked lawyer this afternoon about his thoughts on whether Ann Peruti should have recused herself from the grand juror case. And what he replied and what he said was, well, he doesn't know this how the U.S. Attorney's Office works, but he does think that it's probably more an issue of as long as he informed his immediate supervisors and then the decision was made, just like with Michael Proctor. Michael Proctor did inform Buchanan, his supervisor, and they decided there wasn't a close enough connection to recuse himself from that. To me, it would have caused a lot of difficulty for Michael Proctor to recuse himself because they only had 4 detectives in the unit, and those were the 2 that were assigned that day, and it was during a blizzard. So it would have caused them a problem to have to get somebody else in. But I don't know why in the grand juror case they just couldn't have had one of the other assistant prosecutors take on the case. So it seems strange to me. What do you guys think?
Well, that's disconcerting that Anonymous thinks that it might be all on the up and up.
Well, no, if she didn't report it, if she didn't tell her supervisors, then that's a problem.
Okay.
You know, we don't know, right? So if she never told them that she went to high school with Karen Reed, even if it's a matter of her saying, I went to high school with Karen Reed, and I haven't talked to her since, or I barely talked to her since, or something like that. Just tell the truth just report, say there's a relationship there.
Right, but Anonymous is saying that we just don't know if Ann Peruti got permission or not.
Right.
Got it.
I mean,
okay.
It is interesting that she deleted her Pinterest account, right? Hours after we reported that. So, I mean, she's worried. Ann's obviously worried about it. And it seems reasonable looking at the totality of the connections where you have Ann's husband working as Deitch's campaign manager, where you have Ann co-prosecuting cases with Deitch in the past. So they're very close, Then Deitch is now becomes the main prosecutor or the main investigator from the U.S. Attorney's Office working on the Karen Reed investigation. It just seems the connection is so bizarre. It's hard to think, it's hard not to at least look at that and say, at the very least, Deitch was probably giving Karen more information than he normally would have because of that connection to Ann.
Right.
Yeah,
Yeah, it just seems too shady. Go ahead,
Well,
Molly.
I think, sorry, I was just going to say that if that representation resulted in her benefiting somehow meaninglessly, then it's a big problem. So we can surmise that perhaps she did, because she was this recommended the sentencing, which was not very much, and even the judge changed it because she didn't necessarily agree with it. So there is that, and that's a big problem. And I still think the recusing, like Anonymous said, well, maybe she did, but I find it hard to believe that her supervisor, whoever that she may have disclosed it, would allow it, given the heat of the trial, that they would allow that without looking at it as a problem. I mean, and anybody who works in law firms understands, and often when you represent clients, you do often do searches whether there's conflict, whether you represent another side or so on. And so that's why that's done. And so if you have a family member or something working on your case, that's a problem. Like, you have to disclose those things. It's not just, oh, who cares? And I went, or my sister, her twin sister, is a good friend of hers. Is that a problem? Like, she should know better than that. Like, if I just find it hard to believe that she wouldn't bring that to the surface and disclose that, and her supervisor say, well, let's get somebody else to do it. So I think I've made that argument before, because it's like, well, it's not a big deal. It's just this, small fry case. It's not like she's going to federal prison for 10 years. So I don't understand why she couldn't just pass it on.
Right, and it seems to be the first case of this kind prosecuted in the state, of a leaking grand juror like that, and so it's definitely precedent setting, and it's always slightly suspicious when the judge has a harsher sentence than the prosecutor. Usually, the prosecutor is going to set it higher, the defense lower, and the judge will be somewhere in the middle. But so for the judge to come down harder is always at least a little bit suspicious, right? I don't know if you agree with that, Maui. And
I do, yes.
yeah.
Yeah. Especially because the judge usually will go with the recommendation of to take the step to add further punishment is unusual for a judge, like you said.
Right. And then I don't know if you've considered this at all. So, my retired FBI source really strongly believes that it would have been normal for Turtle Boy to have been prosecuted related to this leaking, because he was the one that was putting that information out on the air. Now, it's not a crime. It's a crime for her to leak. It's not a crime for the media to report it. But but if you use that information in a criminal way, so if you use it to intimidate witnesses, or if you use it to in any way obstruct justice. So if you're putting out that information before a trial, that would be obstruction of justice. And I don't know, but I'm not a lawyer, so I'd have to, we'd have to get a lawyer to talk on that.
But that was subsequent to the verdict of the trial, though, anyways, wasn't it?
But the leaking went on before that.
Okay. So, and he was and this person was disclosing that, and he was disseminating it. So it can be used as an obstruction of justice, definitely. Right. But we don't know. I mean, there was rumor that perhaps they were looking at, both Reed and Turtle Boy for those charges. But
that would be the state. That would be the state. They did have at one time they did have a grand jury, and they failed to indict. But what I'm talking about is the federal government. And
well, that's what I mean. I thought perhaps I've heard rumor that the federal government was looking into those things as well.
I have not heard anything on that, and I don't think we would probably know. So you have obviously people have speculated on that, but I have not seen any indication that that's likely to be the case.
But I don't know if a state can charge
for
a federal crime,
right?
Though, right. So
I wouldn't think so.
That would be up to the federal, So I don't know. I mean, it seems like nothing ever gets done on these, like nothing, for example, Reed, she, deleting all her information on her phone. There was no obstruction of justice destruction of tampering with, tampering with evidence. She never got a charge for that, which she should have, because she deleted the phones right there, right in front of the MSP officers, right? So, it doesn't seem like that. Nobody seems to be catching charges except Turtle Boy. So,
I mean, I think let me just say quickly. I think there's no question that the U.S. Attorney's Office wants this to go away. We don't know exactly what's here, but even if it's just stuff that looks fishy, it looks bad. It looks fishy, and they don't want that. So, and that's what they care about. So I think that's why they don't pursue any of this. It's not going to make them look good. But I'm sorry, go ahead.
Want it to go away.
Yeah.
I think that's the stance on both the state office as well as the federal. They just kind of want this whole thing to go away. Particularly with Reed.
Mm-hmm.
Because why, like we talked about this morning on Kate's Spaces, like about her phones going back and why she's not catching charges for these witness intimidation. Like, why aren't they indicting her? The Cox girls even said, the evidence is there, may not need it, but why aren't you just get her indicted?
Mm-hmm.
Hey, Maui, what are your thoughts on the hearing today? I really appreciate your input.
My understanding, her attorney did make points of how quickly there has to be a turnaround to point that they rectify it. So, saying, this happened inadvertently, please delete, as well as there is case law to support their argument. But I think also that it's up to the judge ultimately, but there is case law to support that it is client privilege, because it went public, it still can remain that way. But I think because the fact that she's disclosing something she's already testified to might be the turning point for the judge to make that they won't be. But he might just admonish them and saying, if that happens again, then it'll be a different matter the second time around. So I think it's a 50-50 here. What do you think, Kevin?
Yeah, that sounds. Am I connected? I think we lost me.
Oh, did Kevin disappear?
I think I disappeared again.
It says he's still a speaker.
Yeah.
Oh, okay.
Can you hear me?
But he's not.
Can you hear me?
He's talking, but
Yeah.
yeah, and so that's how I see that, because I think there has to be a timing matter. So say if I say.
All right, guys. So it looks like now I can't even hear Maui on my end. So I'm going to leave that Spaces meeting. But thank you for Earl and Truth and for helping us host that Spaces. And thank you, everybody else, for being here. And thank you for Maui for your excellent opinions on it. You guys all know Maui from here. And unfortunately, we got a pretty good solid 20 minutes there of uninterruptions, and then started to get the disconnects again. And I don't really know what to do about it. I have no problem with the Wi-Fi. None of us does in this house on our YouTube, but YouTube has buffering. So if it disconnects for a fraction of a second, you don't know it. So I don't know. I'm not really sure what else to do to make that Spaces work better. And it's also frustrating that when it disconnects, it will reconnect and show your microphone is active, but no one can hear you. So Elon's got to get on the stick on that one. So I guess we'll call it a day. I'm not sure when we'll be back on. We'll be on soon, though. I'm going to research some shows. Like I said, that was 3 years ago that I did the Mara Murray one. So we'll do that, and Brianna Maitland, and anything that's been I didn't even realize there had been some new information on that stuff. And I started looking up, and it's nothing earth shattering, but there is some new information. So we can look at that. We'll have to tread lightly, because like in case like Maura Murray, her family's still alive, right? Her dad is still alive, her sisters, and they're very much involved in bringing the case to the public's attention, and they have their own opinion. They have reasons for believing what they want to believe that are just very natural for someone that's their family. So when I had done a series on it, I didn't have anything conclusive, and we'll look at the newest evidence. And, one possibility is she was abducted. Another possibility is that it was a suicide. She was in a state that day, apparently breaking up with her boyfriend or something like that. And she was very distraught, no question. Another possibility was that she just was walking for help and got lost and ended up falling into the woods. If you look where she would walk from her car right there, if she went forward, very dangerous spot, because there was the road goes right along a river with a swift current and a lot of ice in the winter. She could have accidentally stumbled down that hill in the dark. I mean, there's a lot of possibilities, or it could even be a memory loss thing. I mean, she was in an accident. She hit a tree. So it's possible she was not significantly hurt, but did have amnesia. That has, there are different possibilities there. But the family doesn't want to have the possibility of suicide. Another thing, they did have the new information that came out on it was regarding DNA. Some DNA was found within the car or on something within the car. So, we'll talk about that. I don't think you just never know about this case. You got to keep an open mind, and you can't get married into any particular theory on any case unless there's very solid evidence. And it's easy to create an emotional connection, but then you get upset if someone explores all the possibilities because there isn't enough evidence. So you have to be careful about it, but hopefully no one will get upset about it. I'm going to explore it in an open-minded way and just look at all the possibilities. Okay, guys, thank you very much for being here. Thank you to Joe and Tom for moderating, and just looking to see if there's anybody I need to say goodbye to. All right, that should do it. And hopefully we'll get something. Hopefully somebody will come forward soon with more information connecting Karen to Ann Peruti. Was Karen at that wedding, Ann Peruti's wedding? We don't know. Even ideally, somebody from the U.S. Attorney's Office will become a whistleblower. Now, I don't know if a whistleblower is likely to come to someone as small as me. They're welcome to. We'll treat it responsibly, but hopefully they'll go to somebody in the media. And actually, I have someone that if you do come forward, I can bring you to an ABC News producer. So please come forward. All right, guys. Thank you.